course, another mistake is the failure to prepare any will. If you don't prepare a will, the state has a will prepared for you in its statutes, and it's typically a will that you wouldn't write if you were left to your own devices. It's a legislative attempt to be fair to surviving spouse and children and other relatives. The next mistake is inappropriate reliance on simple wills. We've talked about a simple will and how it works and how it can create some tax issues, and we also talked about if you do a simple will, you're missing out on opportunities to provide management for beneficiaries who have special needs and to protect assets from the beneficiary's creditors and from long-term care costs. The next mistake has to do with who will be carrying out the instructions that you leave in the will. Too often, people provide detailed instructions in their will and they don't give enough thought to who's going to carry out those instructions. That person is called the executor. When the will is admitted to probate, the probate court appoints the person who is nominated to serve as executor by the terms of the will. As a result of the probate court appointment, the person who is appointed takes on the duty to carry out the instructions contained in the will. That means that the executor takes on the duty to collect the assets of the decedent and to use the assets to pay the bills and expenses, to pay the debts, to deal with taxes, to sell property, and to make the distributions to the beneficiaries as directed in the will. It can be a complicated job. One reason why we like to do these estate planning and estate settlement seminars is so that people can get an understanding of what the executor's job is and they can make a more informed decision about who to appoint as executor. Earlier we talked about trusts and trustees. The job of a trustee is usually related to longer-term management of trust assets. Compare that to the job of the executor, which is more short-term. The job of the executor is to make sense of the puzzle that decedents leave behind and to collect the assets and clear things up, pay the bills and the debts and taxes and the expenses. When that's over, the executor finishes the job of handing the remaining assets over to the beneficiaries. Sometimes the will directs that estate assets are to be handed over to a trustee of a trust. We've talked about trustees and trusts a bit before, so you have a good idea of what that means. The trustee's job is one of management, investment, and keeping in touch with the beneficiaries. The trustee's job might be long-term. Clients often think about naming individuals to serve as trustees, and usually they first look to family members. But not every family member fits the profile of an ideal trustee. Most families are lucky to have even one family member who would fit the profile of an ideal trustee. But if your family does include a person like that, that can be a good choice. Sometimes clients will go through the list of family members and they'll think, I really don't have somebody who knows enough about investing or finding good investment help, or taxes or finding good tax help, or accounting and finding good accounting help. Management of a trust may require all of that type of knowledge and experience. If the client thinks that there is no person quite like that in the family, the client might look to trusted advisors that they've known for a long time. That could include lawyers and accountants. If the clients can't identify suitable trusted advisors to serve as trustee, they start thinking about banks and trust companies. Although clients seem reluctant to select banks and trust companies, that's too bad, because that can be the best choice for many people, because banks and trust companies that are in the business have a good deal of experience and expertise when it comes to the management of assets and investments and keeping track of the beneficiary's needs. Often it makes sense to name a bank or trust company as trustee together with an individual, making them co-trustees, so that the bank or trust company can take care of business matters and the individual can be the one who's more inclined to stay in touch with the personal needs of the beneficiaries. When the client has young children, the appointment of a guardian for the young children is very important. The guardian can be named in the will. Young couples often have trouble agreeing on who should be named as the guardian. That's one reason why they don't get around to preparing wills. But it's much better to name somebody as the guardian than to leave the selection for argument or guesswork after death. The guardian's job is to look after the personal needs of the children, make sure that they have adequate shelter, education, training, healthcare, and all of those types of things that a parent typically takes care of. And if there are any assets that go to the minor, then the guardian's job also is to take care of the assets. Actually, there can be a guardian of the person of the minor, and there can be guardian of the estate of the minor. And you can name a different person for each of those jobs if that makes sense. Naming guardians for minor children is a very important reason for younger couples to prepare wills. Another mistake is failure to adequately plan for cash needs. Imagine the situation after you pass away. There will be debts, there might be taxes, you might have back income taxes, and your individual income tax return must be prepared and filed, and the final income tax paid. In addition, there might be estate taxes to pay. There are also expenses to pay: the funeral expenses, probate court expenses, attorneys and accountants' fees, and the executor's fee. You may be the family breadwinner, and people may be counting on you for their support. But once you're gone, your income is also gone, and that might create a cash need if you want to provide proper support for your survivors. And then you might be leaving legacies, gifts of dollar amounts to certain individuals. The planning process should take into account all such cash needs. People who have businesses frequently do not plan adequately for management and control of the business after they pass away. It's important for people whose businesses are a large part of their estate to take care of that part of their estate planning. There's another tax we haven't mentioned until now, and it's called the generation skipping tax. Generation skipping tax exemptions have become very large, keeping pace with the estate tax exemptions, so the generation skipping tax has become a less important consideration for most people. I won't take up too much time with it, but it is worth mentioning because, as we've seen, the tax laws related to inheritance have been the subject of a lot of change. Whenever your will establishes a trust and there is potential for that trust to pass down to younger generations, that's a generation that's younger than the generation that's right under you, there is potential for a generation skipping tax. We like to make certain that our wills include provisions that allow the executor and the trustees to make decisions to minimize or avoid that tax as much as possible. The will can grant to the executor and trustee a lot of powers related to the allocation of generation skipping tax exemptions to those types of trusts, so we like to make certain that our wills include those types of powers. We just finished talking about quite a few of the estate planning mistakes that people make. Another important mistake involves retirement plan accounts. We will talk more about retirement plan accounts in our next segment.